All right, good afternoon. This is the Thursday meeting of the House Judiciary Committee. We've got three matters on for the day. From your list, you'll see there's actually four items. One's a resolution, but you have House Bill 808, to which I'm author, House Bill 927 by Representative Comer, a resolution by me, and then we have the Senate Bill 255, which is the Senator Stone's garnishment bill, and I'm going to take the garnishment bill as the first item for consideration. And before we start out, Senator Stone, I want to just go back and give some information and background to those who are attending today and maybe listening in, to let everyone know what we've gone through to get to where we are today with reference to the garnishment bill. As most everyone will recall, back in, I believe, August, one of our U.S. District Court judges had a case under consideration, the Strickland case, in which the court found that the provisions in our garnishment law did not address some necessary due process provisions relative to debtors, and that issue specifically was that where a debtor defendant may have funds that become attached through garnishment, and those funds are considered to be exempt under various provisions of the law that address exemptions, that person should have a expedited hearing, and our law did not call for that hearing. In fact, in the Strickland case, I believe the case took over 180 days before the trial court, in fact, conducted the hearing. So that was one of the deficiencies, and also the fact there was not really in our law or a means by which a defendant, debtor, was given appropriate notice of what those exemptions may be and what their rights might be as a means of filing a claim with the court to have a hearing. So those two major deficiencies were concerned to the court. They were concerned to, I think, the practicing bar and certainly the judiciary of our state. Some of us began looking at the areas of law, and first of all, I know from my past dealings with the garnishment law through the several years I've been here, it was a very difficult, convoluted, patchwork piece of law to try to even follow. You had sections set up that were repetitive but have different terms to be used, different ways to proceed, whether you had a regular garnishment as opposed to a child support garnishment as opposed to a what we call continuing garnishment. So with all these issues facing us, and now with the court decision, it was felt it may be a time for us to try to look at a total rewriting and more reclassification and design of our chapter on garnishment. And we did undertake back, I believe, in the September, to put together a group of attorneys and judges to begin addressing this. I called it a task force because, as persons who were not members of the legislature, it could not be formed as a regular working committee, but we were calling upon those individuals who had expertise in various areas of the law dealing with garnishment, whether it would be in the banking side, the creditor side, and the debtor side, as well as the Attorney General's office, which handles work in that area, as well as for the state, and also some judges. We have two of the judges here that worked with us extensively during that time, Judge Jacobs and Judge Purdom from the DeKalb State Court. We started, I believe, first week in October, if I recall correctly, and we met Thursday, had lunch in this room, and met in this room for probably 3 hours at least every day, and that went week after week, all during October, November, and up through the mid part of December when we completed our work. And what we did, we put together a bill that is a true and complete rewriting of the law, but we did not change a lot of what we call the policy provisions, the stated public policy of the state dealing with the garnishment law, we did do some refinement. And those areas of refinement were really to try and do a balancing of the interest of the creditor, the debtor, and the garnishees as far as what they would have to do and how they would handle the needs in their particular areas. I know that some people have concerns about what we've provided in the bill on timing, for instance, of the location of funds in a bank account and the attaching of those funds and the payment into court. We felt that the time had come in Georgia, recognizing so much is done now electronically. The means of doing the reporting work could be expedited without having to go through a 30-day period of time for a bank to make the filing into court. So we've tried to recognize expediting that. We've also put into the law a series of forms. And although we had in the current law a suggestion of what could be forms used, we are now changing those maybes to thou shalt. So the forms that we're using now will be absolute forms to be used by the courts, by the parties, in all circumstances where there will be a garnishment action filed. It would be required by the plaintiff. We met the notice provision. I'm not trying to go into things Senator Hill will talk about. Senator Stone will talk about. But we recognize in these forms, for instance, it lines out in detail the notice provision to be given a defendant, which is to be mailed by the plaintiff as a part of the current obligation to mail to a defendant. A copy of the garnishment will include this form. It is also going to be used by the garnishee, for instance, the banks, where the bank is filing their response and they're sending a copy of that response to the garnishee. We want to be sure the bank would also send this form. Why are we doing it duplicative? Because we think the bank may have a more current address, perhaps, than would a plaintiff in filing the action. So there would be two copies of this notice going to the defendant. It provides in these forms clear understanding of what the rights and obligations of the defendant if is seeking to make a challenge to the garnishment. And the point being, to go back, that we've tried to strike a balance of the interest of the plaintiff creditor as well as the defendant and of the garnishee. So the forms we have will be mandated to be used. The bill calls for this act, once it does and hopefully pass the House and is given to the governor to be signed, I would hope expeditedly. I think I saw Mr. Teague here a moment ago somewhere. Mr. Teague, there you are. Thank you. The governor's chief counsel, that we are planning to get this bill to you and the governor expeditiously, and upon his signature there will be a 30-day period of time before the bill becomes active. And while we're doing that is we've told the courts already, get the word out. We told the clerk's offices, get the word out. Here are the forms you're going to be using. Start recognizing them. If you want to, get them copied. We don't think there's going to be any changes made in those forms, so we've tried to get that information as clear as we could out to all parties that will be dealing with it. And so we're hoping to ask the governor to look at this favorably, and I know it's taking out a course of action, but to have this bill signed very quickly once it passes the House. There are those who have come today, I think, with a thought in mind of amending the bill. And I want you to know that I'm not open to amendments. We've had the bill in the Senate. As people talk to me from the beginning, I said, if you've got a concern, I want you to take it over to the Senate while they're considering the bill, while it's under review in the Senate Judiciary. Talk to Senator Stone, talk to others relative to what may be suggested changes. And I believe Senator Stone can address the fact that there were some changes made. But the point we are now is I want the bill to be brought through. And not to say that next year there couldn't be some tweaking. many times with the large change in law that we're doing as we have here, there will be what we call a follow-up tweaking. And I think of the evidence code that I was involved in. We did a little bit of tweaking with that. Thought we had it all covered, but there were some things that we had to look at the following year to make adjustments. I look at the rewrite of the juvenile code that we did a couple years back that I was involved in. There were some minor tweakings that we done of that as the bill was implemented and being used, and things recognized weren't operating completely as we wanted those things to occur. So there may be some tweaking next year, but the point is that today, where I am as chairman and one of the persons involved since the genesis of this project, we want this bill put back in force. Why? Because as we sit here today, the judges will tell you we don't have the ability to do garnishment in Georgia, and there is a need for it. We recognize that as a tool that is necessary for the citizens of our state to have, and so we're trying to get it back in place as soon as possible. With that background information by me, Senator Stone, I hope you indulge me with that part of it. I want to turn it over to you and let you start addressing your bill, which is Senate Bill 255.
Thank you, Mr. Chairman. And before I get started, I want to thank you for all the countless hours that you and Legislative Counsel, Ms. Travis, have put into this, and all the voluntary input from all the stakeholders. It was a good group, working group, and a lot of different views were aired, and I think the product of that process was a good, clear rewrite of the garnishment code, which is mostly in Title 18, Chapter 4 of the Georgia Code. I'm going to give you just some framework issues, or lay out the framework, and take questions if Chairman will indulge me. Sure. This is there are several articles to the bill, and part of the reason for that is you have four main kinds of garnishment that are dealt with. Two traditional forms, what I would call traditional garnishment, which allows for a garnishment period of 29 days to capture debts or obligations and or property of the defendant. That is intact. The financial accounts period of garnishment is shortened. It's 24 hours. This is, as the chairman noted, is partly due to the changes in the speed of electronic banking now. And it also reflects some input we had from some of the large banking institutions in Georgia who have to deal with garnishments regularly. And it's come to our knowledge that in the service area in many of the southeastern states that they operate, 24 hours for other than government benefit type issues is the norm. So there's been a lot of discussion about lengthening that. We resisted doing that primarily because of the input from the largest garnishees, the banks that I refer to, and also we did not want to risk anything that would cause extra time other than what's laid out for the expeditious handling and adjudication of a garnishment or any claim to garnish funds. and property. Because that expeditious treatment and resolution was one of the 3 issues raised in the federal case. That is, lack of notice of exemptions, lack of notice of the process to claim exemptions, and the lack of an expeditious way to resolve it. This bill, I believe, adequately deals with all 3 of those, and at the same time takes note of the evolution of garnishment practice in Georgia. The garnishment code has not been rewritten in roughly 50 years. Some of the terminology had grown arcane, and it was cleaned up, modernized, and clarified, and in the process we come to SB 255. Now, the 2 traditional forms, traditional garnishment and the financial account garnishment, are dealt primarily in Article 1, which is a general applicability article, and it lays out the basic process, the affidavit of garnishment, what has to be in the affidavit, the summons that's issued, who issues the summons, and a new concept, the attachment. The attachment is something that is there to assist or aid the garnishee in locating assets or locating the defendant in the judgment that's being garnished. But because it contains information that is deemed private, like Social Security numbers and that type of information, it is not a public record filing. That is the attachment. The notice to the defendant in the garnishment is dealt with, as Chairman has indicated, in 2 ways. One, from the service by the plaintiff to the last known address, and then secondly by notice coming from the garnishee, who typically will have more current information as to the whereabouts of the defendant. One of the things that the garnishment bill does is clarify the claims procedure, not just for the debtor defendant, but also for third parties that may have an interest in those claims. And there are forms for how that is dealt with, and I'll briefly refer to the forms. We have 20 forms altogether, each for different types of garnishment, each for the different pleadings that go with each type of garnishment. Article 2 deals with continuing garnishments. That is your traditional wage garnishment, and it is very similar to current practice. Article 3 deals with continuing support garnishments. That is where child support or alimony is being collected through the garnishment process, and the differences are in that type of garnishment. A larger amount of disposable earnings are subject to garnishment. The garnishment continues for a longer period of time until the arrearage is paid, or the person is no longer employed by the garnishee. There are towards the end, in sections 3 and 4, areas that are really not part of the garnishment code, but are areas that are impacted by garnishment. For example, section 3 deals with tenant holdovers. The form of the affidavit that's used in that scenario refers to the garnishment code, and so we have revised that to refer back to the new provisions in the garnishment bill. Section 4 deals with spendthrift trust, and since it also references garnishment, it is included. I will point out one other area that is the way that we approached complying with the federal court's order, and that is in the notice to the defendant, the defendant is not only given a procedure to follow if he wants to claim the funds as being exempt, but it also makes reference to a list of exemptions. The code, this bill does not specifically list all exemptions, but the procedure for making that known is twofold. One, the Attorney General, State Attorney General, will maintain a list online and periodically updated of what are the exemptions in Georgia, and secondly, that list will also be maintained by the clerks of court around the state. So that information, we did not try to include all that in the forms, but it is dealt with in that manner. One last thing, and I know I'm jumping around, but I'll try to fill in the details with questions. We've done away with prejudgment garnishment in this bill. The prejudgment garnishment has always had its own constitutional issues, and in the process of writing this, coming up with the task force to put together this bill, we found that by and large it's unused in Georgia, so rather than leave that in the code, it's now gone. Mr. Chairman, that covers the bill in its overview. I'll be happy to answer questions.
Let me add just a couple of thoughts, if I might, in conclusion. What you mentioned about prejudgment is true, and what you really have available to you is the equity powers of the court that can require property to be held and seized. For instance, if you have somebody who's known to be potentially leaving the state with the property, the court can exercise, the Superior Court could, equitable powers and have that property restrained and held in the state subject to that garnishment action proceeding.
And you still have receivership and other forms of relief.
And one last thing we did a change to, if you practice law in the state long enough, you've had a client come to you as a business client and say, they've got a default judgment against me on a garnishment. And I'm in a terrible hurt. How do I respond to this? Well, we've recognized that in the past there are those who have, by means of having service of the default judgment, not served, who might be the officials of a business that would have knowledge of it. They would serve perhaps a clerk or someone else of that nature, and you had a statutory time, I think it was 60 days under the current law, in which to respond to that notice. Well, if you look at 18.424, we've changed several things here. We now recognize that if there becomes a default, in order to open that default by the garnishee, the plaintiff will have to have appropriate service made, as we require under 911-4, which means you require in a corporation someone who is appropriate officer or official of that business to receive those papers. So you're not just serving as secretary at a desk. You have to get to the right person with those papers for service. And then you have up to 90 days to get that response to get the thing opened up. So we try to do some balancing there again to make the the service of this more equitable and give the business owner appropriate information about it. I believe we have some questions for you. I believe, Mr. Fleming, you'd like to address it.
To my favorite senator, my senator. Thank you, obviously, for all the hard work that went into this. Were you here all the days that the chairman was here?
I was on the phone.
Okay, all right. Waynesboro's a long way from Sandy Springs, I understand. Obviously, a lot of labor went into this, and I do sincerely appreciate the effort. Just a general question, and then a couple of specific ones, if I may. In layman's terms, what was wrong, and what did we change?
Well, what was wrong, there's the constitutional problems, and then there's just the passage of time problems.
Okay.
The constitutional problems were the lack of notice in two areas. That is, that there were exemptions, because that's not common knowledge, for people, that they have a right to claim some of their garnished assets are exempt. So
okay.
that was one. The other was, how do you go about procedurally making that claim? And the law was not clear at all as to how you could make a claim of exemptions in garnished funds. So that is now crystal clear. We've got a claim procedure, and it's an expedited claim procedure. Once that claim is filed, court has a very short time fuse to rule on it.
So we fixed what the judge found wrong, and we updated something that hadn't been done in a long time.
Right, that's what we did.
My specific questions go to something that the chairman has already referenced as being one of the potential issues for being addressed at some point in the future. I think that's on page 4 of the bill, on line 98, 99. Help me understand that issue. There was a time where, when you filed your garnishment with a bank, for example, that thing was good for 30 days, right?
Right.
And now we're moving that back to 1 day.
That's right.
Okay. And the idea behind that was?
Well, one of the big ideas was that that is more in line with the practices around the country now. But it's also, it had to be shortened, because if it was not shortened, then we would run into that constitutional defect of expeditious resolution. When somebody's wages are tied up, or their workers' comp benefits in the Strickland case, the longer you open up the garnishment period, the more delay you build in to a determination of the defendant's claim.
So going from the 30 days, which we used to have under Georgia law, to the 24 hours, did we bring it to where we thought we had to for the judge's satisfaction, or could that be maybe 10 days? We could cut it by 2/3 down to 10 days rather than 30 days.
Well, I believe the 24 hours is a good period, and that was not one of the areas of discussion that I had a lot of participation in. So I defer to the chairman.
It's really the banks catching the funds as they receive a garnishment. They turn to the records in that account, and in that account there's money.
Yes, sir.
And they will seize that money as far as the garnishment direction. And then they have up to 10 days to file it with the court. So what we've done is really had a photo shot. Garnishment served. Within 24 hours, the bank has an obligation to check the account, what's in that account, seize it, then prepare to file their answer to the court. So it is an expedited case, as Senator Stone pointed out, as a means of meeting the requirements that what we believe to be the direction of the Strickland decision. And it is based upon what is done in other jurisdictions.
So, Mr. Chairman, what we did was, used to be when you filed your garnishment, there was a 30-day period where any money that came into that account, the garnishment attached to it, and that was paid
I
to
think
the
it was
person
actually
who owed
20
money.
days.
20 days?
20 days and then 10 days to file the answer. So you could have up to 30 days having this done. 35? 30 to 45. Thank you.
All right.
Appreciate it.
So
We got some knowledgeable people in the office.
I bet they're going to tell us about it in a little bit.
Probably are.
Yeah. So we went from that 30-day, 35-ish 30-day period down to just 24 hours.
Well, 10 days and you file the answer.
But the only time that the money is captured is during that 24-hour period.
Correct.
And that's only with bank account garnishments. Your traditional garnishment still has the 29 days.
The chairman was talking to us earlier about the opportunities to hear this. Was it your committee? Was it?
It was.
It went to non-civil.
Yeah.
About the opportunity to amend this in the Senate, and everybody,
Mhm.
had a chance to be heard there. Was there anybody that came before you as speakers that asked y'all to change that?
They did.
24 hours to 10
They
days.
did, and we decided not to.
Okay. All right. Did you admonish them like our chairman did about
No,
adding the members?
absolutely not. We solicited input, and a lot of good ideas were implemented.
Okay. The other area that I wanted to ask you about, and I know some people are going to speak on that, so the other area that I wanted to ask you about was over on page 12 of the bill, and that was lines starting on 377 down through 380. The sentence, even when earnings are held at financial institutions, such money may be exempt from garnishment due to the limitation on garnishments provided, and then it cites several code sections there. Did y'all have some discussions about that?
We did.
Tell me about that.
The bill in its original form had something similar, but it wasn't as clear. What the intent of that is to clarify in Georgia, because there wasn't any judicial guidance in Georgia that we were aware of that made the determination that, for example, direct deposit wages that come into account, whether if a debtor can show those are wages, whether they should still have some limitation to garnishment that's in both state and federal law already. And we came down on the side, and other states have done this as well, but not all states, that those proceeds could retain their character as wages. Now, there was a lot of discussion about not placing a burden on the garnishee to make that determination, and I think as written, the bill does that. The garnishee, if you look at the answer form for a garnishee financial institution in the article that has all the forms, you'll see that all that's required of the garnishee financial institution is to show what he has. It's totally, if there's going to be a claim that any of those funds are wages and subject to garnishment limitations, it has to be shown by the claim filed by the debtor.
So what I'm trying to understand in my limited knowledge of garnishments, when I used to do this back when I was a baby lawyer, if I'm garnishing someone's bank account under previous Georgia law and my garnishment hit, it captures whatever is in that account pretty much, and that is paid to the person that was owed the money. However, if I went and garnished your paycheck, then there was a formula involved whereby I could only take about 25% of that, because we didn't want to take someone's whole paycheck because we didn't want to stop them from being able to pay the light bill or whatever, so it was limited on that. And so the question is, with the language in making these references to these code sections, are we confusing the idea that when the garnishment hits the bank account, you can take whatever's in there, versus that concept which are referenced in these other code sections that limit it to 25% because it's wages?
We're recognizing here that if a debtor can show that those are earnings, that the claim can be adjudicated. It's solely up to the debtor through the claim process.
So why that change, though? Was this one of the requirements?
Well, one
that
of the
federal
things,
courts put on us?
it is in somewhat an anticipation of challenges, but it also recognizes that 30 years ago there wasn't the incidence of direct deposit that there is today. It's so become so common that
a lot of companies require a direct deposit.
Right.
And the part of this was Mr. Fleming recognized the balancing of interest, in this case, of the wage earner, who still has the opportunity and the obligation. The burden will be on that party to go to court and prove to a judge that these are earnings that were a direct deposit or other means put in there. He isn't just saying, no, you can't get it because it's my money under wages. They've got to establish that before the court as a factual issue.
So along that line, Mr. Chairman, as a procedural matter, if I claim that my paycheck hit and I had $4,000 in my account and $3,000 of it were my paycheck, I, as the garnishee, well, I guess I'm not the garnishee. Who am I?
Defendant.
I'm defendant. I, the defendant, have to. I file a pleading.
You got to file a claim.
Claim in the garnishment action.
Correct.
And say that judge, that $3,000 was my paycheck.
And show.
Okay.
And show by proof, and then it's up to the court to make that determination. That would be the factual issue for the court to decide.
Now, can it be money's fungible? So if I have let some money build up in my account, which I don't do as often as I like because my wife has access to my account, but she always spends it on great things, for the record. But so I mean, if my paycheck goes into my account and I've let, for some reason, a large sum of money build up in there, say $20,000, is it just my last month's paycheck that can't be hit? Or is it all the money that I've been saving in my checking account?
We haven't made that delineation in the bill itself. We've left that up to the courts to evolve. And it's been suggested first in, first out, different things, tracing, whatever, but it's still the debtor's burden, and it doesn't come up if the debtor doesn't make a claim.
That's a real big change, isn't it?
Mm-hmm. Well,
yes.
There were no appellate decisions on that.
No, it used to be if you put your paycheck into your bank account, it was subject to garnishment. Now we're fixing to stop that.
We got some judges here, but I think you still had the ability to go into court and do it. It's just whether or not you had anything in the statute describing that right, and now you have a description of what that right would be.
Thank you, Mr. Chairman.
Ms. Weldon, is that you?
That's me. Thank you, Mr. Chairman. Back over, we were talking about the 24-hour period. What?
Page 4.
I think so, on page 4. Yeah, on line 9899. And I see what you're talking about here with the garnishment will last from the time it's filed until 24 hours. I guess to the next, is that the next day or the next business day? If it's filed on Friday and the bank doesn't open or the financial institution doesn't open on Saturday, does that mean 24 hours and ends literally 24 hours, or is it 24 business hours?
It starts from the point of service, and it's 24 hours.
I think we've had that discussion during our advisory committee, and the measurement under the law is 24 hours is business hours.
Right.
I mean, by that period of time, right? So if you had it hit on a Friday at 4 o'clock, you really talked about Monday till 4 o'clock.
Okay.
Monday was a holiday, then you have to.
There you go. Monday the holiday, you go to Washington's birthday, you go the next day.
And just one more time,
Yes,
more thing. Senator Stone, can you just articulate the good policy for the state of Georgia that supports having that period of time for the to have that a garnishment be effective for that 24 hours?
Well, it simplifies for the garnishee what what type of monitoring of an account has to take place during the garnishment by shortening the garnishment period, and it helps assist in the expediting of the determination, because it was a financial account decision that was involved in the Strickland case. And the longer you hold the garnishment period open, the more delay you're going to build into the ultimate determination of whether exempt funds have been captured.
Any other questions? Ms. Bill?
No, thank you.
If there are not any other questions, we have several people who have signed up to speak on the bill. I know these are attorneys, and I'd like to also recognize we have here today, I want Judge Purdom and Judge Jacobs, who served on it. I see Adam Cleveland's name here. Adam, I don't see where you are. Where you behind the pole there? Who also served on this advisory committee. And I think we have a lot of good input. If you have signed up, I want to hear from you. But I have to try and, because of the numbers you have here, I see 1, 2, 3, 4, 5, 6 names done, all the same, apparently, pen. Or if all of you are going to speak on the same thing, could you at least collectively have one person speak as a part of your comments? I have James Carroll, David Cleaver, I believe Brent, is it Stolnick, Adam Cleveland, Harriet Eisenberg. Harriet, I know where you, Harriet. There you are. And then Ben Mentor. Are all you going to speak on the same subject of the bill? All right. We'll start out with James Carroll. Mr. Carroll.
Thank you, Mr. Chairman, members of the committee. I'd particularly like to thank Senator Stone and Chairman Willard and Jill Travis and also Jordan Reed for all the time and energy you've spent on this. I know it's been a long process, and I just want to let you know we appreciate your hard work in this matter. My name is James Carroll. I work for Rogers Law Offices. We represent primarily creditors, including several large financial institutions, including Bank of America, the FDIC, and other creditors. I was not part of the task force, so I do appreciate you giving me the ability to be heard today. I'm testifying in regard to the 24-hour provision that we've already heard some testimony on, and against on page 4 of the bill, lines 98 through 99. And the reason why I believe this 24-hour provision is problematic is because a garnishment is not always a one-time hit. A lot of times individuals and banks have deposits going into their accounts all the time. For example, individuals may get paychecks. Businesses often get direct deposits from their customers, from different suppliers that send funds into the account at different times of the month. So if you just have a 24-hour period, then you miss all those other deposits, especially because under federal regulations, financial institutions have up to 6 business days in some cases to clear checks. So even if a check is deposited the same day as the garnishment, you may miss it if it doesn't clear for another 6 days. So the 24-hour period is just simply too short to catch a large of those amounts. And that's especially a problem for a business, because a business may be getting a direct deposit every day, 1 day a month. In order to catch those, you would have to file 30 different garnishments, which would be an incredible burden upon the judiciary, an incredible burden upon the defendants, an incredible burden upon the garnishees, an incredible burden upon the creditors to file 30 different garnishments if each garnishment only has a 24-hour period. And moreover, the 24-hour period, I believe Senator Stone mentioned he believes that's necessary to expedite the garnishment, but respectfully, I would put before you that the 24-hour period is not necessary to expedite the garnishment, because the defendant will get notice within 3 days no matter how long the 24-hour period is. So if the defendant gets notice and realizes that they have exempt funds within the account, they can file their claim even before the garnishee files their answer. So the hearing can be heard just as expeditiously as it could be under a 30-day period as it could be under a 24-hour period. So the 24-hour period is not necessary to expedite the hearing of the claim. The hearing of the claim could be heard just as fast if it was still a 30-day period as it could under a 24-hour period. And I would respectfully request 2 fixes that I believe can ameliorate the 24-hour problem. The first is that on line 98, when it says garnishments, I would respectfully ask that the chairman and the members of the committee to say garnishments of an individual defendant. And the reason why I'm suggesting of an individual defendant is that this would clarify the 24-hour period does not apply to businesses. And I'll be honest, a lot of times garnishments are money that's owed from a business. And a business does not invoke the constitutional issues imposed by Strickland. Obviously, a business doesn't get Social Security disability funds the same way an individual does. So if a business owes you money and you can garnish them, there's no reason to limit that period to 24 hours because the business may be getting a different check-in every day of the month, and you need to have a 30-day period for that. So respectfully, I would ask that if you're going to limit it shorter for individuals, you would clarify that that only be as to individuals, because that was the only constitutional issue as to individuals raised in Strickland. So I request that businesses stay at the 29-day period. And secondly, if there is a necessity to limit it shorter to individuals, I would request that the individuals be limited to 10 days. And so the change made in that case would be to replace the phrase next 24 hours on line 99 with the phrase 10 days, and then the answer on line 276 and 277, which the bank has to file their answers, could be not sooner than 10 days and not later than 20 days. Now, obviously, 10 days is my preference. If the committee would prefer to limit it to 5 days, I would still argue that 5 days is better than 24 hours. But 24 hours is just not enough to catch all the deposits, the direct deposits that are modernly coming into bank accounts. As Senator Stone has stated, a lot of times everything is done by direct deposits, and we're just going to miss most of those direct deposits if it's done within 24 hours. That's not
That's a matter of timing, isn't it?
Yes, Mr. Chairman, but we'll have no idea what the timing is for the 24 hours. The creditor doesn't know the exact day the defendant's getting paid. So that's why we need a longer period than 24 hours.
Right.
It's very rare that I know as a creditor's attorney exactly the day the deposit is coming in.
Thank you, Mr. Carroll. Next, we have David Kleber, if you're going to address a different point.
Thank you, Mr. Chairman, members of the committee, for allowing me to talk before you. And I'll echo everyone else's sentiment of thanking the chairman and Ms. Travis and Mr. Reed for all their hard work, as well as all the members on the task force in putting this together. You've done a great job of clarifying many of the provisions. I want to address two of the provisions in the proposed bill as being inconsistent with the state of the law. I think the provisions in here are contrary to the law, and I would ask the chairman to reconsider his position on amendments with respect to these two provisions. One is the one that Representative Fleming already brought up, and this is the issue on page 12, lines 377 through 380, talking about the cap on wage garnishments as it applies to bank deposits. The entire issue of caps on wage garnishments comes out of federal law. There's a federal law, 15 U.S.C. 1673, that provides for those caps, that says that that federal law dictates that no more than 25% of disposable earnings be garnished from a person's paycheck, and a percentage of or a multiple of minimum wages be exempt from garnishment. And the federal courts have addressed this issue on whether those wages remain capped when deposited into a bank account. And nearly universally, the federal circuit courts, including our own 11th Circuit, have found clear as day that the wage cap does not apply once they're deposited into a bank account. Federal law is clear. Our own 11th Circuit in 1990 said, once commingled with other funds, wages lose any exempt status they may have had. It couldn't be any clearer. And circuit courts across the country have found the same way. That federal law is that these federal caps on wages do not apply once the funds are deposited into a bank account and commingled. Because the federal courts recognized the undue burden placed on banks and the courts in determining all the things that Representative Fleming brought up. How do you determine how much wages, what the percentages are? How does a bank or a court possibly determine how much is 25% of disposable earnings in a bank? Once the funds are deposited, all the bank knows is there was a direct deposit from an employment company. They don't know how much the wages were, how much of those funds were wages and other compensation. So I'd ask the court to, or the committee to consider taking that provision out as it is contrary to federal law. Secondly, I want to address a question that we haven't talked about, and that is on page 14. This is on lines 456 to 459. This is something that Senator Stone brought up in his presentation. I know it's something that I believe was added on the Senate side after the task force. And this involves the bringing of a claim by the defendant that the funds in the bank are subject to the claim of a third party who may have a superior lien on those funds. And certainly the law is that a superior lien holder, a creditor that has a superior lien on the funds, can file a claim in the court and get access to those funds. And certainly I have no objection to that. But the provision here provides that a defendant may raise that claim on behalf of the third-party creditor. In other words, a defendant can come into court and say, you can't have these funds because a third party who's not a party to this case has a superior claim to those funds. Now, I have no problem with the other provisions in here that allow a defendant to raise that claim or to give notice to the third party of that claim. But if the third party does not come into court and raise that claim on their behalf, this section seems to imply that a defendant can prevail on a claim that the defendant raises on behalf of a non-present third party, a third party that hasn't raised a claim to those funds.
It's not the case.
Well, that's what the law says.
It's providing notice to the court that there is a potential other claimant that has a right to those funds, but the defendant himself or herself is not be prosecuting that claim for the party. It has to be the party brought in by whatever means necessary to have them appear before the court if they wish to. But it's not the defendant's right or obligation to defend that. It's just bringing notice to the court.
Correct. Well, and I understand that. I understand that that's the intention, Mr. Chairman. I would respectfully disagree. That's what the law says, because right now under subsection 18419C, it's entitled "When the defendant prevails upon the trial of his or her claim," and under subsection C,
his or her claim.
Correct. And under subsection C, this section 4 says, based on any legal or statutory defense, or that money or other property in the possession of the court may be subject to a claim held by a third party that's superior to the judgment described in the affidavit. So it implies that a defendant can prevail upon the trial of his or her claim that a third party has a superior claim.
And we'll let the court interpret that. It's not intended. I think the court recognizes that's not what the defendant will be prosecuting on behalf of that other claimant, but just merely saying there is another claim out here. I'm bringing the court's attention. If there's something to be done further on that, the court can do so. All right. You have a question?
When you say the case law is absolutely clear that when a paycheck is commingled into a bank account, it no longer has the protections of a paycheck, have the courts failed to address at any point the time of automatic deposit or required automatic deposit of paychecks?
I'm not specifically aware of that situation. I know that they have recognized that the congressional intent of the federal law in their interpretation was clear that the banks were not included in that the intent of Congress in enacting those caps was to protect the employer-employee relationship, and that it was designed to protect only garnishments that are filed on the employer. And recognizing, they have said, the fact that only the employer really is in a position to make those determinations as to what percentage of the paycheck is disposable earnings under the law, and that once the money goes into the bank account, it's unreasonable to expect the bank to do that. In fact, the Ninth Circuit said banks and other financial institutions would face significant cost burdens if required to make the determinations demanded of it by this proposal. So when interpreting federal law, the federal courts have pretty universally said it's unreasonable to expect the banks to make those kind of determinations, that once it's in a bank account, it's funds in a bank account, and it loses its status as wages.
And the wage earner's remedy is to file the affirmative. I've been trying to figure out where the remedy is. If you're saying there is no remedy.
I'm saying once the defendant deposits the money into a bank account, then those funds are fair game for a creditor to attach under garnishment. Any more than if they buy a house with the money, that house is subject to foreclosure, levy, lien. Right. The fact they put the money in the bank does not protect the money as wages anymore.
The way that sentence reads, just to follow up with what you're saying, it says, even when earnings are held at a financial institution, such money may be exempt from garnishment due to limitations on garnishment as provided in the code sections 18405 and 18453. It's not automatic. It's something, again, for the defendant to raise and the court to look at and determine what the evidence is, recognizing either it was earnings put there and they have the exemption to apply or not. Same has been the law, but now it's in black and white. correct?
I would respectfully disagree.
Well,
I think the federal
all right.
law is that once they're in the bank, they're not subject
Not
to that
dealing with
claim.
federal law on the point. We're dealing with what we talk about here and what's actual practice in Georgia. Thank you, sir.
Thank you.
Brian Skolnick, I believe it is. If I can pronounce that incorrectly, I apologize.
That's all right, Mr. Chair. Good afternoon. My name is Brent Skolnick. I'm an attorney with the law firm of Zach Hyman Mavrar. First of all, Mr. Chairman, members of the committee, thank you for allowing me this opportunity to speak. Ms. Travis, Mr. Reed, thank you for your hard work on this bill. Mr. Senator Stone, thank you very much. I'm going to endeavor to make my comments brief, but I would like to address the section that we are talking about, the proposed 18-4-15A, subsection A. Again, page 12, lines 377.
I'm not going to have to go on. I said I don't want repetitive comments. We got a number of people to sign up, and I'd rather have each of you had the same writing for all of you on here. I don't know who did it, but so I recognize that a group of lawyers here want to talk on it, and I've asked to speak on just separate issues. If one has already spoken on it, I prefer, if you would, because of time limitations, not address the same thing again.
If I may, Mr. Chairman, just
Be brief.
briefly address one point
All right.
pertaining to this issue, just to clarify it.
I want to recognize the rest of you. Please, as my learned counsel, Mr. Fleming says, I'm admonishing you, please try and keep it to the different points. Thank you.
As a lawyer, that's hard for me to do.
I
I'll do my
understand.
best. I do appreciate the discussion, the questioning from Representative Fleming and Senator Stone with regards to this section as to how it plays out. That's the question that I and my colleagues have. How does this play out in a courtroom? We've heard comments that we're going to wait for the courts to evolve on this issue, but I would respectfully ask each of my colleagues here, who are also members of the bar, to put themselves in the courtroom and ask how our colleagues on the bench are going to determine this. There's no bright line rule. We have a bright line rule when the 25% disposable income cap is determined out on wage garnishment. We have bright line rules. We're not going to have one. And what my fear, and I'll wrap up with this comment, what my fear is over this year before hopefully this committee comes back and examines the law a year later, could we be creating a potential forensic accounting nightmare for magistrate court judges across the state? And that's my only concern, Mr.
Well, I'll ask them that. We'll let them respond to that, because they were involved very deeply, the judges were, with the drafting of this, and that's specific language. And they've told us that this is something that does come up from time to time. They have to address in claims being filed by defendants. Although it was not a black and white letter in the law about it, they knew those exemptions exist. So we merely have the language here that was already being used by defendants to say, wait a minute, my direct deposit went in that account, and it's part of my wages. So the courts had to address it already. That's what we're talking about. Mr. Clothing. Thank you.
Thank you.
Adam Cleveland.
Mr. Chairman, you've already covered all the points that I would raise.
All right. Ms. Eisenberg.
I agree. I'll cover all the
Very well. Thank you. Mr. Minner.
Mr. Chairman, members of the
Read.
committee, thank you for hearing me today.
Yes, sir.
My name is Ben Minner. I'm an attorney, solo practitioner in Columbus, Georgia. I represent creditors and debtors. And I would bring to the committee's attention a single word that I think would be expedient to alter, but I understand you're not
Let's see
willing
what
to
the word
take any amendments today. But if you look at line 131 of the legislation, this is proposed section 18.4.6 subsection A3, and it reads, funds in an unfunded plan maintained, and it goes on. Well, by definition, an unfunded plan does not have funds in it. An unfunded plan, such as the ones identified here, are really like salary. It's a deferred compensation that comes out of a corporation's bottom line. So I think it would read it would be more sensible if it read funds from an unfunded plan maintained by an employer. And doing so would also parallel the language of line 124, funds or benefits from an individual retirement
Yes.
account. And then
I would ask Mr. Stone, I believe this is the amendment that your chair of Senate Judiciary put in there, which to me doesn't have any meaning anyway. I'm telling you, it doesn't have any meaning anyway.
well, sir, this
It's all
is
about top hat plans.
yes, sir. It's a
The
risk of
top hat plans do not currently have an exemption, and I can't imagine them becoming exempt, but I appreciate you bringing that point to our attention.
Okay.
Did somebody have a question? Did you want a question? Excuse me. Thank you, sir.
Thank you.
Ms. Scott Stevens? Yes, sir,
Good afternoon,
Stevens.
ladies and gentlemen, Mr. Chairman. I just had a few comments regarding the 25% limitation on bank accounts and the
Why don't you lean up so
the
people
24-hour
wanna hear you
period.
in that mic there.
I've been representing creditors for nearly 30 years. I live in Cumming, Georgia. I practice with the Howe law firm in Alpharetta. And can you hear me all right?
There are people outside this room that need to hear you.
Oh,
what
all right,
you're
very
saying.
good. My point, the point that I want to make, because my colleagues have raised most of these issues, my point is that the Strickland case from Judge Shube did not address any of the issues about a 25% limitation on bank accounts, nor a 24-hour period for garnishments. And I think what is happening here is that creditors are being greatly prejudiced by this limitation, whereby creditors are going to have to continually incur more and more filing fees. About 5 or 6 years ago, the filing fees in Georgia doubled. So now, when a creditor files a lawsuit, they're going to have to pay about $250, and then for each garnishment they file, they're going to have to pay another approximately $250, and it just becomes a very onerous burden on creditors. So I would ask the committee to consider those issues.
Thank you, sir.
Thank you.
Last we have is it Kim Jackson? Kyle Jackson. Excuse me, Kyle. I missed.
That's right. My handwriting's terrible. Thank you, Mr. Chairman, members of the committee. I'll be very brief. I appreciate the work of Chairman Stone and you, Chairman Willard, as well as the rest of the working group to address the need to revise the code. What's that?
Who do you represent?
Kyle Jackson, Georgia Chamber of Commerce.
Thank you.
And I appreciate all the hard work and would ask for your favorable consideration.
That's it.
That's it.
Well, thank you so much. Is there anyone who would also like to address the committee before we close off public comment? Any judges want to say anything?
I'll comment on what...
Come up front. Come up, Judge
I'll
Purble.
comment on what Representative Fleming raised. And it was quite clear to us on the committee from asking around that many trial courts were permitting the wage exemption to fall into bank accounts based on Georgia law. Not all... We didn't have the evidence to know what percentage were, but it was clear in many cases that was, upon challenge, being a claim that was allowed. So the question became how to clarify the law one way or the other. But it was quite clear that there were many trial court decisions that were permitting the tracing of funds to permit the wage exemption. And it's also clear it wasn't uniform that way.
Mr. Fleming, you want to ask a question?
Yeah, thank you, Judge. So when the money hits the bank account, and there's $3 or $4 more grand in there that were wages from previous months, when does it not become wages? Judge?
I don't have an answer to that. The answer I have is only that challenges were being raised on this, and they don't come up that frequently. It's not that often the defendant raised it. But asking around, when trial courts were faced with that, they were often ruling that the wage exemption followed into the bank account. That's my only comment. I'm not.
Would it be your preference as a judge that we give you clear instructions on how to handle that in this legislation?
Well, whether it should be now or later in cleanup legislation is something I don't want to address. My guess is judges will follow the same rules followed on Social Security in the interim.
Thank you.
They'll follow the federal rules on how you trace Social Security.
Thank you.
And again, the burden of proof will be on that wage earner defendant to show specifically this is wages that were put in the account, not something just hypothetical. Thank you. Mr. Jacobs, you want to say something? We'll always love to have you back before. Hello.
And to Judge Purdham's point, I mean, I think it's important to just point out that this isn't any different than what some courts are already doing. Now, it would apply to all courts, obviously, and clarity is certainly in the hands of the General Assembly. But I don't know that
it never has been that good, anyway. So.
I don't know that it changed. I don't know that it changes the state of the law with regard to what some courts are already doing. And aside from that, just wanted to thank Chairman Willard on behalf of Judge Purdham and myself for having us on the task force.
Mr. Chairman, he looks so much better since he's taken the bench, doesn't he?
He looks happier.
He looks happier, rested. Yeah.
All right. No further comments. We'll close off further public input. The Senate Bill 255 is now in the breast of the committee. Do we have a motion? Motions do pass. Do we have a second? Second. It's been seconded. Do we have discussion? Mr. Fleming.
Mr. Chairman.
Yes, sir.
About the only thing I fear more than my chairman is my judges. And I don't want to send out something that if we took just a little more time in the committee to work on, that we might straighten out some of these obvious things that are here. I know was it last year that the federal judge's decision came down? I mean, how many months ago was it? And will maybe even 1 week make that much different just to try to address some of these things? And of course, if we send it back to the Senate, an agree or disagree is a one-day thing. And if we can get some consensus on that, Senator Stone could do that. Since we didn't have a subcommittee hearing on this, could I throw myself on the mercy of the chairman and say, let's talk about some of these issues just for a few days here. It's relatively early in the session. Can we please do that?
I'm not going to entertain. You want to entertain a tabling, or what you want? What's your motion?
I'd like the chairman doesn't have to call the vote unless he chooses to, and I wanted to make those comments before a motion was made.
I do.
So I guess at this point I would ask the chairman, please allow us to make a motion to table it, and let's talk about it just a little bit.
And I will. It's not a motion. Your motion is to table. It's not a debatable
I'm asking
motion.
The chairman permission to make the motion to table.
All right. I'm going to respond just to the fact that it's not just a week. We've been without, frankly, a law in Georgia addressing the ability for these fine lawyers who do creditors' work to do much of the work they are necessary employed to do since back in August and September. And I think it's relevant that we try to get this done. We put this in an expedited basis from the Senate side to get it done over there. With the understanding we got over here, I was going to expedite it also to get it to the governor's office. So I do not entertain a motion to table. Further motions? Further comments?
I have a motion.
Yes, sir.
I'll make a motion to adjourn.
Motion to adjourn. All right, sir. You got motion to adjourn. Takes priority. All those in favor of the motion to adjourn signify by saying aye. Aye. Opposed, like sign. No. Motion fails. Next motion. Any further discussion? There's no further discussion. We'll call the question, which is the motion do pass on Senate Bill 255. All in favor signify by saying aye. Aye. Opposed, like sign. No. Chair rules the motion passes. Thank you. Thank you.
And Mr. Chairman.
Yes, sir.
Can you carry this?
Yes, sir. I will.
Floor of the House.
I'll give you all a minute to clear out, if you would, please.
Thank you for allowing us to voice.
Yes, sir. If y'all want to leave, I ask you to expedite your exit, and we will hear the next bill. We have now before us Mr. Comer with House Bill 927, which is the Appellate Jurisdiction Reform Act of 2016.
Thank you, Mr. Chairman.
Let me talk for a moment, Mike, to clarify what we're doing here, if I could, please, sir. If you look in your file, members of the committee, you'll see LC 296938 ERS. That's the correct one? Or this, I know we had two. One came from you, Mr. Comer. One we had prepared with Ms. Travis at Legislative Council. So we're working off of 6938. Ms. Travis, ERS, or what?
I think the one you want to work from is the one that Representative Coomer did, which is 39.
I can go make copies for everybody.
Made the wrong one then.
And
Okay.
39 incorporates the amendments.
Has the amendment already part of it?
Yes, sir.
Okay. Okay. Speak of it.
We got them. We're going to pass them around.
All right. We've got it. We're going to pass them around. Yes, sir. Thank you. So if everyone's clear, we'll be working off LC 296939 ERS. Mr. Comer.
Thank you, Mr. Chairman. I'm glad y'all got all of your disputing and rancor out on that last bill. So y'all can just very kindly and gently pass my bill out of your committee. We are working with LC 296939 ERS. Let me just kind of give you an overview. The legislation before you would alter the jurisdiction of the Georgia Supreme Court and the Court of Appeals, as well as change the number of justices sitting on the Supreme Court and change the terms of court. That's a third provision that's been added in to the latest version you have before you. And just a little background. Under the 1983 Constitution, the jurisdiction of the Supreme Court is split among three broad categories of cases. First category includes writs of certiorari, discretionary cases where the Court of Appeals decisions may conflict, and I'm going to ask you to pay special attention to that piece because we're going to come back to that, and that's discretionary cases where Court of Appeals panel decisions may conflict, or a question is certified to the court by the federal courts. Second, constitutionally mandated cases within the court's exclusive jurisdiction include cases involving the construction of a treaty or the constitutions of the United States or the state of Georgia, as well as cases involving election contests. And finally, the court is provided by statute with appellate jurisdiction over the following types of cases: cases involving title of land, all equity cases, cases involving wills, habeas corpus cases, cases involving extraordinary remedies, divorce and alimony cases, all cases certified to it by the Court of Appeals, and cases in which the death sentence was imposed or could be imposed. The governor established the Georgia Appellate Jurisdiction Review Commission, which studied the, as its name indicates, appellate jurisdiction, and that commission developed a report concerning the appropriate allocation of appellate jurisdiction between the Supreme Court and the Court of Appeals of Georgia. That commission recommends that the cases that some of those statutory cases be transferred over to the Supreme Court for jurisdiction, from the Supreme Court to the Court of Appeals for jurisdiction and review. Those include cases involving title of land, equity cases, cases involving wills, cases involving extraordinary remedies, and divorce and alimony cases. So the Supreme Court would keep jurisdiction over the death penalty cases as well as habeas corpus cases. The change would promote uniformity among court decisions of precedential value while also freeing the Supreme Court with the resources necessary to carry out that body's other functions, including establishing uniforms of practice and procedure, adjudicating attorney discipline cases, and governing admission to the bar. The jurisdictional change would also bring Georgia in line with the modern standard among states with an intermediate appellate court of having one Supreme Court with primarily certiorari and other discretionary jurisdiction. The bill before you also
encourages or also would change the number of justices sitting on the Supreme Court from 7 to 9. The 1983 Constitution authorizes the court to have 9 justices, or up to 9 justices, and we currently have 7. The addition is necessary as a reflection of the likely increase in certiorari cases that will be heard by the court and its continued administrative burden. There are really 2 justifications for adding the additional justices: the workload as well as efficiencies that we hope to obtain. With regard to the workload, by changing the jurisdiction, we are going to send some number of cases that have been heard by the Supreme Court over to the Court of Appeals. It's about 30 or 40 cases from last year's caseload. But our expectation is not that the Supreme Court caseload will reduce it by the same number, but rather our expectation and the indication we have is that the Supreme Court will be able to replace those cases by taking up additional numbers of cases, primarily to clear up the conflicts that may exist in the Court of Appeals panels. And this is a major concern of the governor's office and of mine as well, because it goes to ensuring we have a fair and a predictable environment for businesses here in the state of Georgia and anybody doing business in the state. Inconsistent Court of Appeal panel decisions can create uncertainty and dissuade business activity in the state. So workload isn't necessarily going to be reduced for the Supreme Court by the change that we're making in the jurisdiction. And that leads me to the second point, which is we're seeking increased efficiencies. Well, you may ask, how can adding 2 justices to the Supreme Court result in increased efficiency? I'm glad you have that question in mind, because I'm going to answer it now.
Burning.
You're feeling the burn, sir?
Yes.
Let me move on quickly. By providing 2 additional justices for the court would be able to divide its work up into panels of 3. Now, they'd be able to consider cases and make recommendations and to the full court. Now, there's some question about that, and Ms. Travis and I did some research today, and it turns out that the Supreme Court could actually have its body meet in smaller panels to review decisions and to make recommendations on decisions to the full panel or to the full court. The Constitution provides that the full court must hear cases and make decisions. So in a court where most of the decisions are paper decisions and you don't have hearings, it's very easy to conceive that these 3 panels could run through a lot more work than they do currently as a full body sitting on every decision. And I sort of liken it to our subcommittee and committee process, where the 3 panels would act as a subcommittee set of the full court, making recommendations back to the full court for its decisions. Finally, there is language regarding the change of the terms of court, and that was requested by the court as well to give them efficiencies that had to do with calendaring and working around holiday schedules and so forth. I can go through each provision individually if you like, or I can simply sit for questions. I would point out you have one other document in your folders, and this is a comparison to the U.S. Supreme Court and other courts in the United States, comparing them to the Georgia court in terms of the number of justices and the workload. And you'll see that comparing justices and law clerks to the other states and to the Supreme Court, our justices have a much heavier burden in terms of the number of cases they get through each year. So even by reducing the number of cases by 30 or 40 each year, when you add in the additional need and get them back up to that same level, they're still going to be one of the busiest working courts in the state, in the country.
Thank you, Mr. Comer. I might add, just to follow up, the calendar portion of your bill is the same thing that passed out of this committee for Representative Pack, and what we're doing is just consolidating to have one bill. His bill, I believe, is still sitting in rules, so this will now put all that matters addressing the courts and their calendars into one bill, correct?
That's correct. Yes, that's correct.
You have questions of the presenter? I think over here. Yes, sir. Mr. Welch.
Thank you, Mr. Chairman. Chairman Coomer, is it not true that the justices currently are supervising or have extensive administrative responsibilities, both in terms of looking over bar complaints and the qualifications of attorneys, not to mention promulgating rules for the courts across the state? And is it further not true that the Justice Nomineus and Justice Blackwell have testified in our Appropriations Committee, in which you've departed and gone somewhere else?
I was demoted.
But that in those testimonies, the testimony, they reflected that they were spending a significant amount of their time fulfilling those administrative capacities, and having the extra justices would help in diluting that responsibility and allowing them more time to focus on the decisions that are important to the administration of justice in the state.
That's correct. It really gets them in line with being more of a truly cert court, and ruling on those decisions that really have the broadest impact, and letting the Court of Appeals do more of the nuts and bolts kind of work.
May I continue, Mr. Chairman?
Yes, sir.
Chairman Coomer, is it also not true that from the Supreme Court's, the study committee's report, that the justices and the staff within the two courts have spending a tremendous amount of time deciding where these particular applications for appeal would wind up going? In other words, there has been some confusion in the past between which court would handle a particular case, and cases are oftentimes pushed back and forth between courts, and that may take a 3-month process for a determination to be made by central staff on the question, and then the court's determination as well. And in doing so, we're creating a level of delay in an appellate process where, the parties' interests are already strained because they've already gone through a trial, or they've already had a decision made on summary judgment. So interests are sitting there pending, subject to an affirmation or reversal by the court. And then you have a prolonged period of time whereby these motions, the motion or the determination of jurisdiction, further delays the justice that you're seeking in the final resolution of the case. And by more clearly specifying who has jurisdiction to do what, we're actually expediting the justice that we're seeking to administer through the Court of Appeals.
That's exactly right. And as an attorney who practices in front of these courts myself, I can tell you that over the years there have been times when I've filed in the wrong court, or I've had to get a second opinion as to where to file, and the courts have been very helpful in making sure we get to the right place. But that can create a delay, just as you say.
Thank you, Mr. Fleming.
Thank you, Mr. Chairman. Mr. Chairman, I believe that when the Chief Justice gave his State of the Judiciary address, he supported these changes that we're making in the jurisdiction of the appellate court and the Supreme Court. Did he not?
He did.
Okay. And the other question I have was to the.
And let me say,
yes.
That was my understanding of what he was saying. I mean, I don't want to.
I understood it that way too.
Yeah.
Okay. And they complained about it a lot. So they've wanted us to do this for a long time, I believe.
Yeah.
So the other question was about Representative Pack's bill, which came out of this committee. And I know we made a change in the subcommittee that the full committee approved, and it was very small. And I guess my question was, is what we have in here, the bill is reported out of committee, or was it the original bill that introduced? Because it was a change.
The language here was taken exactly from the LC that is pending in rules right now.
Okay, good. Thank you. That's what I wanted to know. Thank you very much.
Yes, sir. Ms. Oliver.
I agree totally that the inconsistent panel rulings and the confusion about where you go and the time lost on that. I'm, based on my work for probate court, I'm the recipient of a lot of pro se appeals, and it's very wasteful. But my questions relate a couple of different matters, if I may. Section 4.2, I can't find any language about panels. Is there language in this bill about the Supreme Court determining to use panels, or are we leaving that totally to their discretion?
No, they have rulemaking discretion, and there's been an argument in the past that they didn't have that ability or didn't have that power. They do. I believe they have the power to break the workload up into panels. Frankly, there hasn't been a lot of incentive to do that. With 7 members, you can't really divide into even numbers, and so somebody's always going to have extra work or less work. But I think through this process and through what has come up through the commission, is there's a desire to become more efficient on the court, and whereas they frankly didn't have a lot of incentive to take up new ideas because they couldn't really break up the work evenly, this will give them an opportunity to do that.
But you're assuming they're going to do that.
I'm assuming that they're going to look for efficiencies, yes.
But you're not assuming that they're going to use panels. If they said that publicly, we will use panels if this is...
I have not. I haven't listened to any other public comment other than what's come up through the commission.
This is a more minor concern, but your provision in relation to law clerks, which begins on 24 and also on 35. I guess I'm used to...
Lines 24?
Begins on line 24, page 1, and then is repeated line 35 on page 2.
Mm-hmm.
I guess I'm familiar with a lot of law faculties where people who are, clerk for the United States Supreme Court, the dean of our Emory Law School, but he's not a member of the state bar. I'm just curious where this comes from.
Sure. And I do remember the Chief Justice talking about this in the state of the judiciary, and this is basically, the situation is they can't hire law clerks as law clerks until they've passed the bar. They can't offer them a job until they've passed the bar. So they have law clerks there who are not admitted to the bar, who are waiting for admission, and they can't offer them a position yet. So this will simply allow them to offer a position to that member or to that person who's graduated from law school and is awaiting the bar results.
But requiring them to become a member of the bar.
Correct. So if they don't pass the bar, like others I've known who didn't pass the bar, they might become paralegals, but they're not going to be law clerks for the court.
Finally, this is a big deal, major deal. Has the state bar taken a position on this on behalf of its 50,000 members? Do you think this has been well publicized to the 50,000 members?
I don't want to speak for the state bar. I do know that I've talked to representatives of the bar who we've discussed the idea that the people I've talked to from the bar are supportive of this, but if there's somebody from the bar here, then I'm sure they can.
Is there somebody from the bar here? Just walked in. Perfect timing.
Oh, there he is. I'm sure Mr. Worthy can address the bar's position.
Does the bar have a position you don't know, Mr. Coomer?
Well, in my discussion with Mr. Worthy, I believe the bar is supportive of this legislation. But I didn't want to say that unless he was in the room to rebut me.
Mr. Chairman, would you like for me to answer that?
Would you want to come up here and take one of the mics and give us the bar's thoughts on this?
Representative Oliver, the bar does not have an official position on this. It has not been taken up by the Board of Governors. However, to answer your question about well publicized, this was publicized to all 47,000 members as soon as it was dropped. It has now been publicized to them on 2 occasions, I believe, and we have heard 0 comments. I was on the Appellate Jurisdiction Review Commission as the representative of the bar. So the official position is that we have no position, but we have also not heard any opposition, and it has, to answer your question, been well publicized.
Thank you. That's helpful.
That's why I didn't want to answer without him here to rebut.
That's good. Ms. Welch, is that yours?
Yes, sir.
Yes, sir. All right.
To follow up on the sections that Representative Oliver has pointed out, section 1-2, isn't this a kind of a fellowship program that the court is looking to put together, not dissimilar from what the Department of Law is also considering doing? In other words, we're trying to create an opportunity for young future lawyers to gain experience in our judicial system or in the Department of Law, and by doing so, hopefully recruit some of the top legal minds coming out of our law school systems to place them in a position where they can not only be effective, but also potentially become some of our top law clerks within our system, and also legal minds and attorneys representing the state.
That's correct.
Thank you. Nothing further from members of the committee. I believe, Mr. Comer, you've sailed through. Anyone else wish to address the committee on House Bill 927? If not, we'll close off further public comment. The bill is now in the rest of the committee. Do we have a motion? Mr. Fleming, you had your light on?
I was just going to make a motion to pass.
Motion by Mr. Fleming's do pass. Is it seconded by Mr. Welch? All right. Motion second. Is there further discussion on the motion? Are there any amendments? There being no further discussion or amendments, the chair will call the main question, which is a do pass to HB 927 as LC 296939 ERS. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries.
No.
No? All right. One no. The next thing we have is going to be two matters that I have been the primary sponsor on. I will turn the meeting over to Mr. Fleming at this point.
Mr. Chairman, which one would you like to move with first?
I'm going to address probably to begin with the House Bill 808, and just from there we'll actually be talking about both of them initially.
Okay, well, let's start with House Bill 808 then, and Chairman, why don't you go ahead and tell us about House Bill 808? All
right, thank you, Mr. Chairman. I want to give a little background history to this matter. This is addressing
Mr. Chairman, which one are you using?
the bill number.
LC.
LC 808, LC 256560. Is not? Oh, there's a substitute. You're right. Excuse me. We did have a substitute. That was the constitutional.
6940.
Yes.
I don't have my packet.
Here you go. You want mine?
All right, I'll proceed, Mr. Chairman.
Yes, absolutely.
History goes back a ways. I have, over my years as first of all as a lawyer, but then as a member of the General Assembly, watched and followed the proceedings of the Judicial Qualifications Commission fairly closely, and frankly have been very supportive and admiring the good work they're doing with regards to the question of first instructing judges of the state, as well as when necessary discipline judges of the state on matters where they've really been out of bounds. And the thing that's happened is, frankly, I think we've had a lot of judges take notice, recognizing they have a answering body here, the Judicial Qualification Commission, that's put them back more in line with being sure they follow what is the published document known as the judges' rules. I think the proper term of it is the judicial standards of the Judicial Code of Conduct, of the state of Georgia, which is published as part of the Supreme Court adopted rules. It's a very large body of rules, as you can see. I mean, it covers pages. I don't know if they're numbered pages, but it's probably over, here it is, 57 pages. And we've had some judges who have really not performed as they should have, and the courts of the state are, I think, in a better place because of the work of the Judicial Qualification Commission. With that background, and saying being supportive, I know they went through some times in the years 2008 through 2013 and 14, as other agencies of the state did, suffering with setback of funds. We have tried, and I think done well in refunding the monies that were necessary for their operation. The thing that I've seen happen, though, in the last probably year has been a change in some of the things happening, frankly, within the Judicial Qualification Commission that bothers me, and I'm troubled by it. And I will repeat what I've said to people on the commission. I want to talk before this committee about it. There was one thing that first came to light, and that was they were hiring an individual who was to be their director. And here is a board and body that should be of the highest integrity of any body, in the state, and they worked out a plan with him that was really circumventing what was believed to be the appropriate requirements, because rather than have this person employed as a regular employee, which has been the practice all years in the past, this particular individual was a retired judge, and he's receiving a pension, his judicial pension from the Superior Court. And so they worked out a plan with him that he could continue receiving his pension by having him employed as a consultant rather than an employee of that body. And it was unknown to people, and then on top of that, all his travel back and forth from his home in South Georgia to attending meetings or being in office were being charged mileage-wise. But all this came to light because we do have reporters in the state that also follow the JQC, and this was brought out by records of that body. And so the JQC recognized they couldn't do what we call a wink-wink contract and circumvent what is the real expectation requirements of having this person as a full-time employee. Change was made. There was a length of time there was nobody serving as the director. Another thing that's happened, I think, that's really brought to the forefront more than most any other thing that they've done or has happened. I don't say it's done specifically at their direction because I don't have all the facts about this, but I've tried to find out, and that is we've had 2 judges indicted, and their indictments grow out of having come before the JQC for interviews. As I find out, when these people are being interviewed, there is a secret recording being made of it. It's not something known by the member of the bar, the member of the judiciary, this judge who's there being interviewed and questioned about particular conduct. And then after the interview, these tapes apparently are used to obtain indictments against that judge for what they consider to be false statements given to a public body under OCGA 16-10-20, I believe the code section is. And I looked at it, and it's kind of a vague language, but it's certainly recognized if you give false statements. It doesn't say false swearing. These people are not sworn under oath, but they're there giving information. So we had Judge Amanda Williams, the first one, indicted. Now, Judge Williams has been removed from the court. She is still under indictment under Fulton Superior Court and the District Attorney of the Atlanta Circuit. The next one we have, though, is Judge C.J. Becker. And Judge Becker served in DeKalb County for a number of years. I remember when she was elected sometime back, I believe like 1988 or 89, as I recall, because I lived up in Dunwoody. I remember the signs up there. But I'd known and appeared before Judge Becker from time to time through the years and knew her to be a very qualified judge, doing a good job. Her rulings were based upon, I felt, the quality of the law that we needed, and she may have been a little short sometimes, but that's what most judges get to when you have a courtroom full of people. They're not always, spend as much time as you like for them on some points, but Judge Becker, I felt, was doing a good job, and I was quite surprised to learn at one day reading the Daily Report that she had also been indicted. I didn't know all the facts about it, but I knew of her having handled a case for the former school superintendent in DeKalb County, Mr. Lewis, Crawford Lewis, so his name was. And there was an issue growing out of Mr. Lewis's having entered a plea, the plea being based upon his giving testimony that was to be truthful as a part of that plea, and the question about whether or not at the end of it the judge found that he was not being truthful. And she refused to accept the plea. So he either had the right to withdraw his plea or he could continue, and she was going to issue a sentence of up to 1 year for his having entered a plea on this misdemeanor that was reduced from felony to a misdemeanor. Now, as a part of that, I have from time there's a published record about the interview of Judge Becker. Now, let me stop and say this interview occurred, I believe, time-wise, get the date back here, excuse me. I believe it was in June. I don't have the exact date, I'm sorry, but Judge Becker had already announced that she was stepping down from the bench. She announced that because she was getting married, and with her new husband, spouse, she would be living outside the district. So the statement she was no longer going to be on the bench was already out there and known. But anyway, she was brought into a meeting of the JQC. And I think here's where part of the egregious conduct that I see happens. She was sent a letter and said, come before the JQC, we want to talk to you. That notice had nothing, said nothing about the purpose for which she was being brought in. Said nothing about what may be potential claims about any misconduct by Judge Becker. Now, she had known of one person who had been in her courtroom and who had been unhappy about the outcome. It was a lady representing herself pro se, and she was not able to get a foreign judgment validated in Georgia, and so she was unhappy about that. And Judge Becker explained to her the law was this judgment was no longer valid. But she knew this lady had filed, I think, a complaint with the JQC. So she thought, when she went to appear before the JQC, it must be for that purpose. But the notice she was given had nothing in it about that. And she arrived there, and the people who were there representing the JQC, several of them, began the interview saying, no, they started talking about the Crawford Lewis trial and the fact that in this trial she did not allow a posted bond, which was not the case. She did not refuse a bond. She was absent from the city. She had told the attorney she was going to be absent from the city at the conclusion of the trial. She was going to the Army-Navy game. I mean, it's all in the transcript. And I would commend any member on this committee to take some time to read this transcript. I've got the tapes, not the tape, but the CDs back here of the actual recording. And it's eye-opening of how, and I've used a term, and I don't use it loosely, there was a star chamber proceeding against a sitting judge in Georgia as to how she was treated. You have one member of this JQC literally screaming at her to the point that Judge Becker's in tears as a part of this time she's appearing before the JQC. And the thing that bothers me also about that is here is a body, is the commission that is being the body to pass upon her guilt or innocence, and they're serving not only as the judge and the jury but also as the prosecutors. And I think it's unheard of that anybody, when we recognize due process applies to each of us, whether we are a lawyer, a citizen, or a judge, should have a certain standards of how these people are being treated. Now, I don't know if it's something gone on for years or not, but you got to realize the JQC is almost a secret body. It's the only body, I believe, in Georgia that doesn't have open meetings. And they have an exemption in the law, so even their business meetings are closed, that the public doesn't have the ability to come in and hear what is being deliberated by them. I understand if they're going to bring in a judge, that should be probably a closed meeting. But I think there needs to be certainly standards as to how these meetings are being held. Now, I'm being told that these things are happening as far as changes being made, but I don't know. We don't have anything that tells us document-wise, here's a set of rules and policies of the JQC that the public should have access to in knowing how they conduct their business. But in going back to this matter about Judge Becker, apparently, and I have not been able to get to the root of it, as to how, in fact, after her hearing, there was then to be this indictment taken out against her, claiming that she gave untruthful statements to the JQC in this meeting that she attended. I'm hearing that, the person who is now the attorney, here's another part of it, it's surprising. They get a assistant district attorney the JQC hires as the, quote, attorney to represent the panel, the JQC body, in this matter against Judge Becker. But the commission apparently doesn't have any say-so or control over what she does. So I'm told that she then goes by, that the attorney who's supposed to be representing this body doesn't receive directions to what she can and cannot do as an ADA, not as an ADA, but as an attorney, rather, for this body. She is a serving ADA. Now, there's a claim then that she has done something untruthful, that she has violated the laws of Georgia. Indictment's taken out against her. We already talked about the fact we know she's stepping down. With the indictment, 4 days later, after she agrees that she will, in her statement, she's no longer going to serve in any judicial capacity in Georgia, the indictment is dismissed. Now, each of us are lawyers. Indictments don't just become dismissed. Was there an investigation? Was it determined that the indictment was invalid for some reason? Was it determined that there's no evidence to support it? No, the judge, the district attorney handling it just goes before the judge and says, we want to dismiss this indictment. And the basis of it was that they had received this plea, or this agreement rather, from Judge, no pleas with it, use that term, this agreement that she would no longer serve in a judicial capacity, and therefore the indictment is dismissed. Now, to me, ladies and gentlemen, that is a gross misuse and abuse of the criminal justice system in this state. And to my mind, it's criminal to handle indictments that way, to use an indictment against somebody in that manner. So that's been bothering me. And I'm concerned about how this is happening. And I hear talking to people, well, we're changing that. It's not going to happen anymore. But the problem to me is it happened once. It may be happening twice already to judges. I'm going to the next thing that's bothered me. I'm getting reports of judges who are sitting and having individuals come in as members of the JQC, practicing attorneys, and not being able to get something done by a judge in their court, not the judge themselves, excuse me, this one instance, Mr. Comer, comes out of the staff of a probate judge in Bartow County. And this member of the JQC comes in and wants to enter a plea on a misdemeanor case, and the staff tells him, sir, to enter your plea, you also have to make an election. Do you want it to be a jury or non-jury? Well, why is that? Because the probate court doesn't handle jury trials. And that's happened to me many times when I'm handling cases in municipal courts and probate courts around the state, traffic matters, and I make an election when I enter my plea. Well, this particular time, the attorney was upset. In fact, he had sent his staff the first day to do it, was turned away. He comes the next day in a rage as I read these affidavits. I've got affidavits, all of you are happy to share those with you. And he is telling the staff person, because the judge is not there, if you don't do this, I'm going to be investigating this office. You know, I'm a member of the JQC, and we're going to investigate this office. So he's using his position as a member of the JQC to threaten other staff in a clerk's office as well as a judge. Now, I'm told it's not the first time it's happened by this particular person. I haven't done the verification yet, but I'm working on it, that he's also done it to another judge, making threats about use of the position, and in fact, he followed through. I've had conversations with people that were parties to the discussions, and they tried to stop it and couldn't stop it. He kept pursuing it. And so there was, I believe, an investigation of the particular judge, Judge Scoggins, and And I don't know where it stands now, whether it's still pending or it's been dismissed. But these are things that have been happening. I submit to you, ladies and gentlemen, that the JQC of Georgia today has lost the substantial ability that it had to do its work, because I cannot imagine one of you judges walking in to a meeting today with the JQC to give statements out of fear that you may be indicted. If I were a judge, I wouldn't talk to you. I'd say anything you want to ask me, put it in writing, and I'll give you a written response to it. But you're not going to talk to me and expect me to be under the threat of being indicted anymore. Now, I say all this background-wise. Why do you bring these things? Because just as I say, I think the day has come, and I don't know if the members of the JQC that sit there today understand and accept that. They have lost their effectiveness as a body in this state by reason of the conduct of individuals. There is no control, apparently, within this commission on what the conduct is of other members of that body. As we see most groups, whether it be a committee like us, another commission of the state. And here's another point about it. You know, this bill that we're bringing is removing the appointment powers of the bar. And everybody says, why are you doing that? Well, these are people who were appointed by the bar. That's a major problem. But also, the bar, let me say, is the only known private organization in Georgia that has the ability to appoint commission members to what is a constitutional body, authorized body in the state. Everybody else is either appointed through elected officials such as the governor, speaker, president of the Senate, those type of things. So this is a little out of the norm of how we conduct business. So I brought these bills, the bill and the resolution is to say the current body known as the Judicial Qualification of Georgia is now brought to an end, and there will be appointed a new judicial qualification body made up of members who are appointed by either the Supreme Court, by the governor of Georgia, and one by the speaker and one by the president of the Senate. So you're back into the norm of how people are appointed. I'm sorry that some people think I'm stepping out of bounds, but I just felt that we're at a place with the need to have a cleansing of this issue and remove this cloud that is currently over the JQC in Georgia. And with that, Mr. Chairman, I will be happy to take questions.
Any questions from the committee members of Chairman Willard on this matter?
I think Mr. Welch has got his.
Mr. Chairman, thank you, Mr. Chairman. Chairman Willard, didn't we also hear testimony just the other day from the executive director of the JQC that
it astounded me
that for as long as that they have been maintaining digital records and files, that those are maintained on a server in.
I'll be glad to address that. You're right. What we found out, I didn't know it until I was talking to him, the question about how his compensation stuff. I said, where is the office of the JQC? There does not exist a actual physical office of the JQC. You have the director works out of his home, and there is a lady who is administrative assistant who lives in Covington. Now, she's in Covington. He's up in Hiawassee, I believe. This lady who is the administrative assistant is a part-time person. She maintains all the copies, all the work records, the files at her home. These are what I consider to be highly sensitive records about investigations of judges in our state. He said, but we got a backup, not just paper. We got everything on digital computer. And it's all on a hard drive. And I said, well, where's the hard drive? Well, it's also in her home. So in effect, if you had a fire in that home, the JQC would be out of business.
May I follow up, Mr.
Yes, sir.
Is this just not, in my mind, the JQC has both an oversight responsibility with respect to the ethical practice of being a judge in the state, but there's also a component of proper administration of staff and the resources that the JQC has. Is that fair to say?
I agree with you completely.
And in my mind, it seems that what we are seeing is that there is a breakdown in the supervision, if you will, of the body. The body itself is not supervising personnel and its resources in a manner that,
and its other members,
in a sense that it's in any sense that would be considered proper or prudent, especially given the records that they're maintaining and some of the activities they've engaged in recently. Is that fair to say?
I agree with you completely.
So since the JQC is not has a substantial portion of the current body as appointed by non-elected and a non-elected board, that the public lacks an ability to effectively remove members from this body, and the body is there to serve the public in the sense of ensuring that the court system is operating in a high ethical manner.
Correct.
So the legislation you're proposing, Mr. Chairman, is legislation that basically says we have a no confidence on the existing makeup and on the fashion in which it's made up because of the lack of accountability to the voters.
I think that's a fair way to put it.
Thank you, Mr. Chairman.
Other questions of Chairman Willard from members of the committee? I don't think we, Representative Weldon.
Thank you, Mr. Chairman. To Chairman Willard, what you've articulated to me is difficult to. It's shocking. I mean, that's shocking, and there's just no sense of due process whatsoever for judges just because someone on the bench, they don't waive their right to due process in their employment or in their treatment by the government. In essentially, the way you feel like this should be addressed is we do away with the mechanism we have now. And what that does, and really the way we're doing that is we're removing the appointments the bar has.
It's the only way we can do it.
Okay.
And I go back, one of the things, Mr. Chairman, another point that it concerned me was we had the JQC issues what we call advisory opinions. And those advisory opinions are really, I might say, I consider it part of and maybe subordinate to what is the rules that are promulgated under the Code of Judicial Conduct. But all these are subject to, these rules are, to the Supreme Court of Georgia. Now, a question was raised about a couple of the advisory opinions that were promulgated by the Commission, and the Supreme Court said, well, we'll take a look at it. And as I gather from press releases and from media videos of interviews and what came out as far as discussion before the Supreme Court, they're in there challenging the right of the Supreme Court to look at their rules, to look at what they do as far as advisory opinions. Just the same we have with the bar. The bar issues advisory opinions, and every one of those are subject to review by the Supreme Court as to whether it's appropriate or not. And that's all the Supreme Court was doing, but they're in there before the Supreme Court, and in fact using a retired Chief Justice of the Supreme Court to argue their position, to make the stand that we've got the right to make the determination, for instance, on open courts. What are the standards to be considered for an open courtroom? Now, all the Supreme Court says, we want to review this, see whether you're right or not, if that's appropriate way to handle that issue. So that was nothing that just bothered me.
Chairman Weldon had one more.
Yes, sir, Mr. Weldon.
Chairman Willard, so as far as I know, and I'm licensed to practice law in the state of Georgia and the state of Tennessee, and there are 3 branches of government: executive, legislative, and judicial. And apparently, and the legislative and judicial, they're subject to the interpretations by the legislative and executive are subject to the interpretation of executive. I mean, of the judicial. Good grief. So apparently, the JQC and those who've been working in it feel like they're the 4th branch of government. Apparently, if they're not subject to the Supreme Court being the final arbiter. Is that what you're telling us?
Well, you can interpret that way. I think they stand autonomous. No question about that. There is no oversight. There is no review of what they do, per se. Now, the Supreme Court says we're reviewing it, and they have to argue about it. So,
wow. Thank you for
other questions from members of
Pam,
the committee. Pam, Representative Stevenson.
Thank you, Mr. Chair, and thank you for the bill. The first question, is there a limitation on the time that the members can serve once appointed?
4 years. They serve 4 years and are subject to be reappointed. And the way it is here, same thing as it's currently. Let me look. I think that's under the existing code section of the, the constitutional provision in the law as opposed to this statutory provision.
So that the time of service is under the
yes,
current. Okay. The other question, because you spoke, and I agree with you regarding the administration and how the failure to have office, keeping the files, the portion that said the commission may adopt procedures for its own governance which are not otherwise provided by the Constitution. Is there any mandate that they provide some types of rules or have an office, those things that you said?
Well, it's not mandated, but it would be certainly a practice that you would think of a state agency recognizing it as part of their need. And that's something we can certainly look into, Ms. Stevens. There's also a document I have prepared that I'm going to hand out to you because I'm going to file it. I would welcome any of you who wish to participate. I'm filing a resolution tomorrow, which will be handed out to you now. And I'm asking the Speaker and the members of the House of Representatives that we participate as members ourselves to appoint a special study committee on the Judicial Qualifications Commission to have 7 members of the body appointed, and that body be given powers to seek testimony of individuals as well as records by subpoena. This is done through the adoption by the House of Representatives. If you look over to the second page, there's created this House Study Committee. I want it to be done during the time that we're still in session. The committee is to be composed of 7 members of the House of Representatives appointed by the Speaker of the House. And the powers they have, the committee shall investigate the operations of the Judicial Qualifications Commission and undertake a study of the conditions, needs, issues, and problems mentioned above as related thereto, and recommend any action or legislation which the committee deems necessary or appropriate. And the committee is authorized to issue subpoenas of witnesses and documents for purpose of such investigation, to place any witness so subpoenaed under oath when testifying before the committee, and they'll know they're under oath as far as coming before this body. There'll be a court reporter there, and to enforce such subpoenas according to law. No such subpoena shall be issued unless it is pertinent to the committee's jurisdiction under this resolution, and any question posed to subpoena witnesses must be pertinent to such investigation. The chairman of the committee may select the names and number of witnesses and types of documents to be subpoenaed. Subpoenas shall be issued by having been prepared by the Office of Legislative Counsel at the direction of the chairperson and signed by the Speaker of the House and attested to by the clerk. So this is the means by which we can get to the bottom of a lot of these unknown and unresolved issues about the specific things that have happened in this autonomous body that serves in a secret manner in our state. And I'm going to be filing this. I'd love to have any of you who will participate as a signee to the resolution.
Other questions? Ms. Beskin, did you have questions? Or Representative, you did?
At the appropriate time, I'd like to make a motion, Mr. Chairman, and then I have a question in relation to the resolution.
We have one more light flashing over here. Was it Representative Welch? Did you have a question? Yes.
Mr. Chairman, thank you, Mr. Chairman. What is the have you put some thought into whether or not there should be some we should include in the resolution, the House Resolution 1113, a statement as to the Supreme Court's review of those advisory opinions? Is that something that we'd want to address now as we move forward with this?
I'd certainly be open to that if you'd like to do that.
Okay. Thank you.
Okay. Are there any other questions of committee members? Did you have a question, or did you want to make a motion?
I want to do both.
Well, I'll take a
first.
question now, but I'm gonna see if there's anybody here else that wants to. Go ahead.
Question. Procedurally, I should know this, but I'm afraid I've not seen this before. This is a House rule this is not a study committee by legislative. This is a House rule that allows us by resolution as a body of the House to issue subpoenas and to create investigatory.
Yes, ma'am. I checked with Wayne Allen with the Legislative Council, and this is the manner by which subpoenas can be enforced through the House.
And is this resolution, if it's filed by the chair, to be voted on by the House in order?
Yes, ma'am.
Okay. And calendared by the Rules Committee? Is that your expectation?
That's correct.
I'd like to make a motion, Mr. Chair, if I may.
One second. We'll get back to you on that. Any other members of the committee have any questions of the chairman on this? Do we have anybody signed up? Did you have a question, Mr. Walton? Do we have anybody signed up to speak on either one of these, the bill or the resolution? Do we have anybody here that would like to do that before we move on? Judge, you want to come back up?
Judge Purdom?
Come on up, and the chairman will cut the microphone on and identify yourself again, because we are on the record.
I'm Judge Purdom. I'm President of the Council of State Court Judges.
Yes, sir.
I want to comment on something that pertains to this bill, and some of it was addressed by the chairman, but the bill doesn't directly address it. One of the concerns of our membership is that there is one body that does the investigation and then determines the guilt or innocence and picks the prosecutor. And I think once upon a time, back before 1970, that's how the state bar used to discipline people. But in the second half of the 20th century, everybody essentially realized that that was not the correct way for regulatory bodies to operate. And that's a fundamental structural problem with the JQC as it's presently constituted. Now, there have been people who have suggested that the JQC could appoint people under them to do the probable cause proceed. I don't know whether that's proper under the Constitution or not, but that is a fundamental issue with the JQC as it's presently constituted. And then there is this advisory opinion issue. Those who are familiar with the state bar advisory opinion process know that the state bar takes comments, allows public comments beforehand, and then before the advisory opinion has weight, it's subject to review by the Supreme Court. And of course the JQC took the position the way the whole process started, we had no idea how you review, or if you could review a JQC opinion. We wrote a letter to the Supreme Court. The Supreme Court decided to set up a formal process. And of course, the immediate response of the chair was to denounce us for what we were doing in public media. Many of you probably saw those stories. And then before the Supreme Court, they took the position that although the Supreme Court has the authority to review a discipline case, they have no authority to review an advisory opinion. But the current Code of Judicial Conduct says that these advisory opinions have the force of law, and judges are bound to follow them. And I don't know that the JQC, as it's presently constituted, is really equipped or funded to, I mean, you have 2 lay people, you have 3 bar appointees who are normally ex-presidents of the bar, and 2 judges, and they come together and they sit in a room and they decide what to issue.
Well, you got some legal minds there that should know what proper procedures
But
are.
anyway, I think there's a problem with the advisory opinion process. It's not addressed by this legislation, although you addressed it in your comments. And of course, some of this does come from the lack of funding of the JQC and the fact it's made up of part-time members, and you know, it's a thankless job.
I agree.
To serve on the JQC, and the Lord knows the judiciary needs an effective watchdog, but judges should have the right to actually have a due process hearing and not be pressured into dropping their right to a hearing by extra legal means.
Thank you, Judge.
But I'm not speaking for or against the actual bill.
Thank you,
Hey,
Judge. Any questions of the judge?
Just a follow-up comment, if I might.
Certainly, Mr. Chairman.
Mr. Chairman. What he says, I've had several people say, well, they're the watchdog, but who's watching the watchdog? And there doesn't seem to be any oversight to that.
Even the House itself, Mr. Chairman, has the ability to impeach judges.
True.
And the Senate has an opportunity to remove them, so there's a review process there.
And I want to follow up on that comment. We saw comments by our colleagues in the Senate, at least one, questioning this whole thing, and I would urge those members to be familiar or become familiar with what are the facts underlying the bringing of these particular measures to a legislative body.
Okay.
Before they make their comments.
Any other questions of the chairman before we bring the bill back to the committee? I think I asked if anybody wanted to testify, and there was no one, so the bill is back with the committee now in front of us initially. You have a question, Mr. Walden?
I guess just thinking through some of these things that Judge Purdom just mentioned, Mr. Chairman,
Hold on one second. We're with Mr. Weldon right now. Go ahead, Mr. Weldon.
I can wait till Judge Weaver gets through.
Okay.
I'll be glad to defer.
All right. Well, hold on one second. Judge, did you want to come up and say something? Please come up if you'd like to. Come on up.
I'm here actually speaking.
Everybody talks in judiciary. Come on up. Welcome today, and tell us who you are.
My name is Brenda Weaver. I'm the Chief Judge of the Appalachian Judicial Circuit, and I was appointed by the Supreme Court last year to serve as one of their representatives on the JQC.
And immediate past president of the Superior Court Judges Council.
I am now the president, but I'm not speaking in either positions.
Sure.
And I'm not even speaking as listening to all the things I heard here today. And I sat here and I didn't know whether I should go outside and throw myself in front of a bus or just, I'm not sure, because I have worked extremely hard on that commission. And a lot of the things that are being indicates that all of the members, or it appears to be that all of the members are not taking this job seriously, and that is really not true. And one of the things that does occur in every meeting that I have been present, before a judge is asked a question, he or she is told that it's being recorded. Now, those rules have now been changed where we're not going to record unless the judge wants it recorded. Because my view was, well, if there's not a recording, there's not anything that we would be required to turn over if a prosecutor wants that information. I was not on the commission when Judge Amanda Williams whatever action was taken. Because of my friendship with C.J. Becker, I recused myself and I was not involved in any of those proceedings. And I'm not saying that to excuse myself. I don't know what happened in that meeting because I wasn't there. But I do know in the meetings where I am there that I and the other members, particularly Judge Patsy Porter, who's a state court judge, attempt very diligently to make sure that the judge is treated in the same manner we would like to be treated. Now, are there some things going on that need to be corrected? Absolutely. We went from having Jeff Davis as our executive director to a period of time we had no director. Then Judge Lane was the director, and then he left. And then there was many, many months, and the office of the JQC was changing during that time period. And now we have a full-time director. We are in the process of correcting many of the things that you've talked about in reference to the records, because you're absolutely correct. They have got to be protected. But only thing I'm saying is that you have a lot of members on there that have good intentions, and we have no desire to do something that would be in any way detrimental to a judge, or in any way would not give that judge the right to due process. And I just felt like I needed to make that clear, that some of the things that are being said, actually, I mean,
Is it not true?
some of the things are not true. They do know they're being recorded. Now, as
I've
to
talked to
public
Judge Becker.
comments,
I've talked to Judge. I'm not arguing. I've talked to Judge Becker. She did not know she was being recorded.
and I just indicated I wasn't
I
in
know
the
you weren't.
room.
I know.
recused myself, but in the room when I am there and there is a judge present, I have never known of them not being told that when we were recording, we're not recording anymore for obvious reasons, but unless the judge wants it recorded, and he or she can bring their own recorder. But in any proceeding that I have been present and a judge was speaking, he or she was told that it was being recorded. Now, I wasn't in the room, but CJ, I don't know what happened, so I can't testify as to that.
Okay, thank you, Judge. I think you have a question. Chairman Weldon?
Judge Weaver, are there procedures such as decorum that are in place when there is or when there was an interview of a judge being questioned, regardless of whether they knew they were being recorded or not?
When they're coming to the room,
Correct. When they're called to the JQC to
usually
meet
there
with
is a
JQC.
letter sent out initially, and on that will tell the general nature of the complaint. Many times the names of the complainant are not on there because they may be lawyers or other judges or people who do not want the judge to know that. So then they are coming to the room. Usually the chairman of the JQC will ask the judge, and a lot of times they'll bring their attorney, sometimes they bring their spouse, sometimes they just bring a friend, and whoever they bring is allowed to come in the room with them. And then the chairperson will explain to them that it's the informal proceeding, we want to talk to you about what's going on. Usually the executive director at that point in time will sort of outline what we want to talk about, and then the judge is given an opportunity to speak before the commission, and then if individual members of the commission has questions, then we ask those questions. The judge has questions. So it's not a situation in which there is like a courtroom setting, if that's what you mean.
Okay. And are those procedures written and published to the members, and are they available to the person who's getting called in?
How it's
the judge who's getting called. Yeah, the procedure and the
inside the room. I'm not sure if those are. If they are, I've not seen them, but that's usually been the practice. We are in the process of. We started this last year, actually, working on the procedures to go along with the new judicial canons. We have not finished those yet. But as far as a step-by-step procedure that we could send to the judge.
What if I'm sorry to,
Okay. No,
and
it's okay.
I guess what I heard earlier was that Judge Beckett was being very argumentatively questioned, and I think that's putting it nicely. Who is in charge of dealing with those type of issues?
The chairman.
And okay, and there's not a set sort of decorum or rules that are written out and available for public review or for review by anyone.
Well, there's procedures in place and policies if this occurs, or the appeal process the judge would have. If the committee elects, if the commission elects to file formal charges, those are filed with the Supreme Court, and then at that point in time, the due process hearing would occur.
Okay.
What we are trying to determine in the hearing, or in speaking with a judge, and you know, for every 50 judges that come in to see us, 48 or said thank you and they get a letter dismissing the complaint. It's very seldom since I've been there where we've had a lot of judges leave. Now, in the years prior to that, I understand there was a lot of judges, but most of the time when the judge comes in and explains the procedure and talks about what happened, those types of cases are dismissed.
So I guess the procedure, there's not really a formal written procedure for the investigative investigative.
It will tell them if we elect to file charges, what the next steps are. Initially,
That's when the due process or the written rules apply. But before that, it's an investigatory type
to see if there's anything
environment.
to the complaint that's been filed, and 98% of the time there is nothing.
Okay. Any other questions, Mr.
No,
Chairman?
thank you.
Judge, thank you for coming. We appreciate you being here today. Okay, now the bill is back to the committee. We're on House Bill 808, and now it's back with us. And Mr. Chairman, did you have another comment?
Yes,
for
I want to have a
Representative
closing
Oliver?
comment. I
Sure.
want to say very much appreciate Judge Weaver's work. I'm afraid that those who are good people serving on this commission have been tainted by conduct of some of the other members on the commission, and it's not where you can stop, because there's no way to say to a commission member who's performing outside of what would be recognized boundaries in their work, you've done wrong, and get off of it. They don't even correct within the commission. They don't correct or try to rein in the improper conduct of one of their members. So you have 7 members, some of whom act on their own, doing what they want to on their own. And that's another problem as I see it.
All right.
I appreciate Judge Weaver's earnest work which she's done.
Thank you, Mr. Chairman. All right, Representative Oliver, you want to be recognized for making a motion on House Bill 808.
I want to echo the chairman's comments about those members of the JQC today that are trying desperately to remove this cloud. That it's such an important organization and such pivotal to our acceptance and respect for the justice system. But I move, Mr. Chairman, that for due pass of HB 808 LC 296940S.
There is a motion to pass. Is there a second? Parliamentary inquiry. Chairman Weldon. That's correct, HB 808. Okay. All right. There is a motion and there is a second by Representative Beskin.
I have a amendment when prepared, Mr. Chairman.
Okay. We'll go ahead and go to that part discussion. Chairman Willard, do you have an amendment?
I would amend 808 to recognize, as brought out, the bill does not establish the terms, and I think what we need to do is put in here that the term, and that would be under, I think, I'm looking at the page, the commission shall consist of 7 members, each of whom shall serve for a term of 4 years, comma, as follows. So I would put it under B.
Ms. Travis, you get that?
On line 18.
Each of whom shall serve for a term of 4 years?
Correct.
Yes, sir.
There is an amendment by the chairman. Is there a second? There is a second. Is there discussion on the amendment? There is no discussion on the amendment. Voting on the amendment, all those in favor, please indicate by saying aye.
Aye.
Any opposed, same sign. There are none. The amendment carries. Any further amendments or discussion on the HB 808 as amended? If none, there is a motion that the bill do pass by substitute now as amended. Any discussion on the motion? If hearing none, all those in favor do pass indicate by saying aye.
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 Any opposed? The bill passes.
Mr. Chairman, I wish
Yes.
to make a second motion of due pass of House Resolution 1113.
There is a motion to pass House Resolution 113, and we have it in front of us. It's the original. There's no substitute. It's LC 256559. Is that correct?
Yes, sir.
All right. Well, hold on a second. Let's make sure we have the right one.
You're looking at something else.
I'm looking at House
You're looking at the
resolution.
resolution at, I'm sorry. That's the study committee resolution.
Yeah, it's at the top. It says House Resolution 113 LC 256559. Everybody got that?
This is the constitutional amendment, Mr.
Yes.
Chairman, am I correct, that's required to go along with the replacement of the existing JQC with the statutory framework that we've set out in House Bill 808.
I believe that's correct, Chairman Willard. Is that
Correct.
right?
That is
okay.
correct.
We do have a motion and we do have a second on the due pass recommendation on House Resolution 113. Is there any amendments or discussion on the matter? Chairman Weldon? I'm sorry, Chairman Welch. Got my W's mixed up.
A lot of them here. Thank you, Mr. Chairman. Being passed out for you is a proposed amendment to House Resolution 1113.
This is not an amendment.
And I pardon, please excuse my poor handwriting. And I also apologize for the staple being at the very bottom right-hand corner. If you would, if I may just read.
Certainly, go ahead.
This would amend the proposed resolution at line 23 by striking the subsection enumeration of B and making that C, and then inserting
in the correct place.
Subparagraph B, the procedures of the JQC, in this case the Judicial Qualifications Commission, shall comport with due process period. Such procedures and advisory opinions issued by the Judicial Qualifications Commission shall be subject to review by the Supreme Court, period.
And that would be, of course, here with this JQC would spell out Judicial Qualifications Commission, correct?
Yes.
Okay. Okay.
And then the second page there's a second page, and if you want me to take them in two forms, I can. But the second page, on the second page, is an amendment to the.
Are they related such that you want to explain both at the same time?
I can, yes, sir.
Okay, go ahead.
And they are related, yes, sir.
Okay.
Line 34 is an amendment to the question, the constitutional question to be proposed that also acknowledges that very issue. And we would add in between the word judges on line 34 and the question mark the following language, and require the Judicial Qualifications Commission to have procedures that provide for due process of law and review of its advisory opinions.
Okay, there is an amendment, and I think they flow together because once you change the resolution, you have to change the question that be placed on the ballot. So I think we probably should take those as one, but there is a amendment on the table that has been made. Is there a second to Chairman Welch's amendment? Second. There's a second on discussion on that. Chairman Weldon, did you have discussion?
At the end, it says to be reviewed by the Supreme Court. Should we also just insert for clarity of Georgia after that, so it would be Supreme Court of Georgia?
The constitutional language that is in this article, and I've just been reviewing this in preparing this language, just refers to the Supreme Court. It does not qualify as the state of Georgia. It's implied.
Okay. All right. Representative Oliver, you had a question?
I will. Why is it necessary to put the procedures of the Judicial Qualification Commission shall comport with due process when you have the second sentence that says procedures and advisory opinions issued by JQC shall be subject to Supreme Court?
I think it's a good question, and to respond, and my thinking of that is that we've just heard anecdotal information about the manner in which the JQC has conducted its business. And I think the overriding issue that has been addressed, I think the question along Chairman Weldon's, the line of questioning from Chairman Weldon, the information that has been presented by Chairman Willard, all indicate that there is some question as to whether or not the judges are giving fair notice as to what they're being brought in for question about. And then in the conducting of those hearings, it seems to me that there's a question about whether or not they're afforded reasonable notice and reasonable opportunity to defend themselves in a hearing that might allow them an opportunity to not be persecuted or prosecuted in a manner that I think most of us would find repugnant to due process.
I do not know the answer to this question. In relation to the Supreme Court's review of state bar disciplinary matters, is there a similar sentence that says they shall be comport with due process, or is that implied in relation to the Supreme Court's general jurisdiction and review process?
I'll refer, and I was looking through the article that we're dealing with just to try to address these issues and make it consistent with other language in the article. So it's a good question, Representative Oliver. Within this article is paragraph 8, and paragraph 8 says due process and review by Supreme Court. It does not speak, and I'll read it to you and then we'll go from there. No action shall be taken against a judge except after hearing and in accordance with due process of law, period. No removal or involuntary retirement shall occur except upon order of the Supreme Court after review. Now, please bear in mind this paragraph follows section or paragraph 7, and 7, of course, follows 6, which is the one we're amending. But 7 speaks to the discipline and removal and involuntary retirement of judges, but it doesn't. But it doesn't actually go into the process and procedures of the JQC. It just actually talks about some authority, the basis for removal, but it does not go to a process or procedure, and it does not address the question that Chairman Willard had raised and the one that is actually being argued as to whether or not the Supreme Court would have any oversight whatsoever. And notice that the language I'm proposing does not go to the decisions of the JQC, but to those advisory and the procedures. So as to keep that autonomy there relative to the third branch of government, the judiciary, but yet still having some oversight that there's fairness in the process that's being executed by that body, by the JQC.
I could argue with you, but I don't think it's worth arguing. And I think that you're. I understand completely the thoroughness of which you make your point.
Any other questions of Chairman Welch regarding his amendment? If there are no other questions, the chair would take both of the amendments at once because they are related to each other unless there's any objection from anybody on the committee. If there's no further discussion, there is a motion to amend as passed out House Resolution 113 by Chairman Welch. All those in favor of these two amendments indicate by saying aye.
Aye.
Any opposed? There are none. The amendments pass. Now we are back to the amended by committee substitute House Resolution 1113. Any further comment or amendments to that resolution? Hearing none, then the amended substitute is in front of the committee. All those in favor of passage, please indicate by saying aye.
Aye.
Any opposed? House Resolution 1113 passage of rules by committee substitute. Mr. Chairman, it's all yours.
We're back on House Bill 808. I think we're going to do that one.
We already did that, Mr. Chairman. Yeah.
We're down to the resolution. I have the resolution, which is LC 2565.
Mr. Chairman, are you going to introduce this resolution?
I'll introduce that tomorrow, yes.
Yes, sir. Mm-hmm.
But I'm asking if anybody want to sign it with me, we'll be glad to accept it. Mm-hmm. All right. That will complete the business before the committee this afternoon. If there's nothing further, we'll stand adjourned.